Welcome to Case. Tonight's case dives straight into a wild courtroom standoff, State versus Miss Saliston. A self-proclaimed, sovereign citizen, she's back in front of a fed-up judge after years of dodging court dates, bench warrants, and legal warnings. The judge's patience? Running on fumes. The defendant's confidence? Sky high, backed by bizarre, constitutional, claims that the court calls pure fiction. But will her fiery arguments finally break the bench, or bury her case for good? Let's find out.
If you keep giving me those nonsense legal claims, and I've been hearing those for 40 years, man. They're nonsense. They're right up there with the Easter Bunny. I don't mean to insult the Easter Bunny. All right. Then we will go to Miss Saliston's case. We will let the state be able to set up. There's very important issues today. Now we were on this. I'll just set the case up and then it's back to me.
All right. 23B 1593 etched in.
Okay. All right. Miss Saliston, actually, as I told her earlier today, I had various important legal issues to take up. She was disruptive. After repeated warnings, she was removed from the courtroom. The next important issue, and if Miss Saliston would quit trying to represent herself, she would have seen this. There was a bench warrant issued for her arrest. She appeared in court on that bench warrant. Therefore, the bench warrant was resolved. An examination by the record indicates that her prior bond had a judgment forfeiture, which was cured. The sheriff levied, it was satisfied, the bond was never set aside. So if she would have spent more time on paying attention to the legal.
What you're hearing here is a classic sovereign citizen argument, claiming the court has no jurisdiction, or that laws don't apply to them. Judges across the country face this kind of thing constantly, and it never works. Notice how the judge keeps emphasizing nonsense gibberish. That's not just frustration, it's a legal cue. He's signaling that her motions have no lawful basis and are clogging the docket. In short, you can't opt out of the justice system just because you disagree with it. And this judge has heard it all before, even comparing her theories to the Easter Bunny.
Principles that actually apply, other than this nonsense gibberish, she would have realized it. But she didn't. So now the state has filed a motion to revoke the vote.
Yeah.
And that's the important matter we're on today. So, and she's entitled to notice and due process. So that's why she was brought over today, because those matters are expedited. So let me hear from the state on the state's motion to revoke bond.
And Your Honor, some of the facts you've already put in the record. I will say that on June 21st, 2023 is when the defendant failed to appear in Ellen. The bench warrant was issued. Subsequently, October 20th, 2023, a bond forfeiture was granted. We would submit to the court that basically for 2 years, the defendant evaded the bench warrant. And it looks like September 16th, 2025, the defendant was arrested by Georgia State Patrol. And that was for new offenses of obstruction, distracted driving, suspended license, and improper use of intent. The state arrest meeting, that was September 16th, 2025.
Right? So after the time she failed to appear in the court, Did she have any other arrests other than this traffic offense?
Not that I'm aware of.
Okay.
And so it wasn't until this arrest by Georgia State Patrol that they discovered the benchmark was unstable. So we would submit to the court that, based on the defendant's own statements in court and her filings, she does not recognize this court's authority. She does not believe this court has any personal jurisdiction over her. And we would submit that any bond condition, she would just ignore. And she does pose a flight risk. Secondly, we would submit to the court that when she was arrested, she basically committed several offenses, which she was out on bond for, with the exception of the fleeing and attempting to elude and the possession of the marijuana. The remaining counts are virtually identical to the counts that she was arrested for: distracted driving, no license, no license plate, obstruction of police. And so we would argue that she violated the conditions of her bond, and she does pose a danger to the community.
Okay. Is she out on probation or parole on any prior offense?
I don't believe so.
Okay. And when she was arrested, did she give a new address?
No, I believe she gave the same address as the arrest.
Which was what?
Yep. Thanks.
Yeah.
The address I'm showing is 2214 Upward Falls Avenue, Latham.
Falls?
Yes. POPLAR. And the zip code is 30058.
Okay. Now, Ms. Salaston, that is the issue before me is revoking or modifying your bond. If you will, I'll give you an opportunity to be heard in the courtroom if you will come in and get to the point of that. If you keep giving me those nonsense legal claims and
This moment right here captures courtroom fatigue at its finest. After 40 years on the bench, the judge is done entertaining fantasy law. But look closer, he's still offering her a chance: come out, be heard, and stick to the point. That's restraint and procedure in action. Even when defendants go off track, due process demands they be given the floor. But when someone rejects the court's authority outright, it's a ticking time bomb, and the clock's about to run out.
I mean, and I've been hearing those for 40 years, man. They're nonsense. They're right up there with the Easter Bunny. I don't mean to insult the Easter Bunny. So you want to come out, I'm glad to hear for you. It's an important legal issue. But if you would have quit trying to represent yourself, you would have recognized that you could have posted bond. reposted bond. But you're more concerned with the nonsense than really what applies. And that is to your detriment. But you have a right to make bad decisions. Thus far, you've exercised them. All right, let's see if she wants to come out and be heard on the issue of revoking her bond. If she complies and she does what she's supposed to, I'm glad to hear her out. If she becomes once again disruptive, she will be removed.
Judge, she said that she would like to come out, so I will bring her to you in person.
Okay, so she says she won't come out of the holding cell. Well, that won't last very long.
No, she will. She wants to come out.
Okay, well, if she'll come out, I mean, I'm glad to hear it's important.
Yes, sir.
So let's see whether or not she will comply this time.
Yeah. So it's an offer. Got it. Is it?
No, it's not. He had to get
All right, Celestine is with us. Ma'am, the issue is revoking your bond. State is contending that your bond should be revoked. You don't agree with any authority to court, and you've been missing for 2 years. So, I'm glad to hear from you concerning what you want to tell me. Now, typically bond is based on whether you're a flight risk. So that's a big hurdle. Been gone. The second one is whether you're a threat or danger to the community. The third is whether or not you're a risk of committing future felony offenses. I've not heard that since you originally posted bond that she had any felony arrests. Is that correct?
Correct.
It's likely that you would pass that criteria. I gotta make all 4. Now, the last one is whether or not you would intimidate witnesses or obstruct justice. I think all the witnesses in this case are wrong.
Yes.
So the likelihood of your intimidating them is just about 0. So the main issues for my reconsideration of your bond is number 1, you're a flight risk. Number 2, whether or not you're a threat or danger to any person in the community. I find that you qualify to the other 2 factors. So what would you like to tell me, if anything, concerning whether or not you should be once again, you should leave your bond where it is right now, which I think was, what was it, 20-some thousand? 30,000. Or I should just strike it. So I'm ready to hear from you if you will get to the lawful point.
Right, I would like to make my statements without interruptions, because if I don't have the right to be heard, then we might as well just.
Ma'am, you have a right to be heard on those issues, because that's the matter
Right.
right now.
Okay.
If you
so
don't
then-
want to talk about those issues, then that concludes this part of the hearing. The other part I've got that I still haven't been able to get through is your Ferretta hearing. They're not gift counsel. You've already missed a huge legal issue on the ability to post bond. And what a bench warrant does after you appear in court. So you're not doing well on your own.
Well,
Do you wish to respond to the bond criteria or not?
well, first, the bond is excessive, and I'm not supposed to have to be compelled to pay any costs until a conviction on a felony on a final trial. So that is my 17th guaranteed protection under the Article 1, Section 1, paragraph 17 of the Constitution for Georgia. And Article 9 of the Constitution for the United States, which you have an oath to, states that y'all are not supposed to deny or disparage any of my inherent rights that are reserved to me. I have reserved all human rights, natural rights, consanguinity rights, birth rights, constitutional protected rights and treaty protected rights. And they have been denied and disparaged as if they don't exist. Those are my retained rights. So I'm trying to understand, what are we doing? What am I supposed to do? What is my way out? I'm constantly feeling like you guys are usurping my rights. I don't even know who this man is, and he's bearing false witness against me. He's got a story that he has just finagled out of anywhere. I don't even know the people on this whole case. I don't know anybody, but I'm sitting here being again accused and not presumed innocent. I'm sitting in chains in a inhumane living conditions. I've never experienced this. I don't have a record. This type of thing is for someone who is actually somebody who is a criminal. I'm not a criminal. I am innocent. And I keep trying to tell you guys my status and my rights.
I have given you your time for a little bit of your talking about the issues that don't apply to bond. Now we're back on.
I did give you Article
the two bond conditions, yes or no.
I gave you Article 1, Section 1, Paragraph 17. I'm not to be compelled to pay any bond, anything, until conviction on a final trial. And I should, Amendment 8, I should not be held under false imprisonment, under cruel and unusual punishment, under any bail. That's the Constitution. And is that not correct, sir?
No, you aren't. It's something else you're wrong about. But anyway, ma'am, I'm once again sad.
Can I judge this comments and opinions be posted on the record?
This is where I'll have you removed, because right now.
You might as well. That's fine. I don't care.
That's fine. But ma'am, you're clearly not going to respond to that based on the arguments before me and the non-response by the defendant. I find that the state has met their burden to revoke bond. So I guess in part you're having it granted. You won't have to pay anything because you're not going to have anything.
Welcome to Case. Tonight's case dives straight into a wild courtroom standoff, State versus Miss Salas Tunn. A self-proclaimed sovereign citizen, she's back in front of a fed-up judge after years of dodging court dates, bench warrants, and legal warnings. The judge's patience running on fumes. The defendant's confidence sky high, backed by bizarre, constitutional claims that the court calls pure fiction. But will her fiery arguments finally break the bench, or bury her case for good? Let's find out.
That's fine.
So,
well, it's not for me, because I'm not, I'm here with the defendant.
Take care, ma'am.
Under be
We should
correct.
make different decisions.
Make the rest and coercion.
All right, take care. All right. That's a shame.